Welcome to the October 2015 Bond Dickinson Employment Law Podcast. I'm Karen Plumley-Jones and I'm one of the practice development lawyers for the employment team here. In this podcast, I'll tell you about some of the major cases that have been reported since my last podcast, dealing with working time, unfair dismissal, holidays and sickness absence, TUPE, and subject access requests under the Data Protection Act. Then I'll go through the autumn 2015 employment law changes before looking at some news stories. Lastly, I'll give you some action points to take away with you. You can pause this podcast and print a copy of the slides so that you can take notes if you wish. This podcast qualifies for CPD points and you can claim for the amount of time you spend listening to it. I'm going to start by looking at the decision of the European Court of Justice in the TUPE case, where the ECJ had to consider whether the time spent by a mobile worker travelling from home to his first customer of the day and from his last customer back to his home was working time under the Working Time Directive. Tyco installs and maintains security equipment in Spain. In 2011, it closed its regional offices and attached all its employees to its central office in Madrid. Its technicians used company vehicles to travel each day from their homes to their customers' premises, returning home at the end of each day. The company did not treat the time spent travelling from home to the first assignment of the day, or from the last assignment back to home, as working time. The workers challenged this in the Spanish court, which referred the issue to the ECJ. The ECJ noted that the directive only recognises two types of time, working time and rest time. It held that, during these periods, the workers were working, they were at their employer's disposal, and they were carrying out their duties, so this time came within the definition of working time in the directive. This decision is relevant to workers with no fixed or habitual place of work, and is likely to affect individuals such as sales representatives, skilled technicians, and care workers. In wrongful and Department for Transport, the EAT had to consider whether undue influence by HR during the disciplinary procedure rendered a dismissal unfair. Mr. Wrongful was employed by the Department for Transport. An investigation was launched following possible misconduct by him in relation to his expenses. A manager was appointed to carry out the investigation and act as disciplinary officer if necessary. He was inexperienced in dealing with disciplinary proceedings, so received help and advice from HR. Following a disciplinary hearing, the manager recommended a finding of misconduct and the sanction of a final written warning. However, following further lengthy communications with HR, the recommendation was changed to summary dismissal for gross misconduct. Mr. Wrongful was dismissed and brought a claim for unfair dismissal. Evidence at the hearing indicated that HR had advised on factual and legal issues that went beyond matters of law and procedure. The Employment Tribunal held that the dismissal was fair, and Mr. Wrongful appealed. The EAT disagreed and remitted the claim to the tribunal. It stated that it was acceptable for a case investigator to seek advice from HR, but the advice should be limited to questions of law and procedure, and should avoid straying into areas of culpability and appropriate sanction. It was, however, acceptable for HR to advise on the consistency of sanctions. For managers unfamiliar with employment law or their organisation's policies and procedures, having the support of HR during a disciplinary process can be invaluable. However, HR managers need to be aware of the limitations placed on their role in this context and must avoid influencing the outcome of a case or the disciplinary penalty, otherwise any dismissal could be unfair. Did procedural flaws in the disciplinary process and a failure to comply with the Acas Code in respect of the appeal panel lead to an unfair dismissal? This was the question the EAT had to decide in Adeshina and St George's University Hospital's NHS Foundation Trust and others. The Trust began disciplinary proceedings against Ms Adeshina following allegations of inappropriate behaviour. The Trust made various errors during the disciplinary process, such as basing the decision to dismiss Ms Adeshina on allegations that had not been put to her during the investigation. Ms Adeshina was dismissed and she appealed. Her appeal was heard by a panel of 3 senior managers and an independent advisor. She objected to 2 of the panel members. The appeal took the form of a rehearing, and the decision to dismiss Ms Adeshina was upheld. She brought various tribunal claims. The EAT found that the flaws in the disciplinary process had been remedied by a rehearing at the appeal stage rather than a review. Although one of the panel members was less senior than the dismissing officer, and another member had had previous dealings with Ms. Adeshina, this did not make the dismissal unfair. The panel included 2 other members who were more senior than the dismissing officer, plus an independent advisor, and the tribunal had concluded that there was no bias in the appeal panel. This decision is a reminder that an employer should carry out a rehearing rather than a review at the appeal stage if there are any concerns about how the investigation and the disciplinary hearing have been carried out. However, it's preferable to ensure that the correct procedure is followed from the outset. My 4th case is Plumb and Duncan Print Group Limited, where the EAT looked at a worker's right to holiday when they are absent due to sickness. Mr. Plumb was on long-term sick leave for nearly 4 years before he was dismissed. The employee handbook stated that employees could not carry forward unused annual leave to the next holiday year unless agreed in writing by the company. Before he was dismissed, Mr. Plumb asked to take the annual leave he had accrued during the whole of his sick leave. The company paid his annual leave for the current holiday year, but refused to pay it for the previous holiday years. Mr. Plumb brought a claim for payment in lieu of untaken annual leave for the 3 previous leave years. The EAT held that workers on sick leave do not have to show that they are unable to take annual leave because of their medical condition in order to be able to carry it over. They may take it if they choose, or take it at a later date. However, the right to carry over holiday is limited to 18 months from the end of the leave year in which the holiday arose. This decision means that workers on sick leave may choose to let their annual leave run into the next holiday year so that they are able to take a longer holiday when they return to work, or, if they leave, they are entitled to a large payment for untaken leave. However, they must take their leave within 18 months of the end of the holiday year in question, which means they cannot accrue unlimited amounts of holiday. Is an employee who is on permanent sick leave assigned to an organised grouping of employees in the event of a TUPE transfer? This was the question before the EAT in BT Managed Services Limited and Edwards and another. Mr. Edwards had been off work for 6 years with a heart condition. He was kept on the books so that he could receive PHI payments, and when they ran out, he received discretionary payments from his employer. He was permanently absent, and there was no suggestion that he would be able to return to work. Following a tender exercise, BT argued that he had transferred to Ericsson on the basis that he remained part of the division that transferred, despite his absence. Ericsson refused to accept him on the grounds that he was not assigned to the division at the time of the service provision change. The EAT found that Mr. Edwards was not expected to return to work and was therefore not assigned to the organised grouping of employees that transferred under TUPE. To be assigned to a grouping, something more than a mere administrative or historical connection is required. There will generally need to be some level of participation by the employee in the activities that are the principal purpose of the organised grouping, or, if the employee is temporarily absent, an expectation that he will, at some point in the future, carry out those activities. Employers need to distinguish between an employee who is on long-term sick leave and is expected to return to work, and an employee who is permanently unable to return. Employees in the first category are likely to be assigned to the undertaking, but the second category is unlikely to transfer on a TUPE transfer. My last case deals with subject access requests under the Data Protection Act 1998. Under the Act, an individual has the right to make a subject access request to find out what information a data controller holds about them. The individual has to pay a fee of £10 and provide evidence of their identity. The data controller then has 40 days in which to comply. In Dawson Damer and others and Taylor Wessing LLP and others, subject access requests were made by a mother and her 2 children for all data held about them by a firm of solicitors. The firm acted for a trustee involved in administering a large trust fund connected to the family and other relatives. The mother was involved in litigation in the Bahamas in relation to the trustee, and the firm had acted for the trustee for nearly 30 years. The firm did not comply with the requests and claimed to be entitled to a blanket exemption for legal professional privilege. The claimant sought court orders requiring the firm to comply. The High Court refused the application. On the facts, and under the disproportionate effort exemption in the Act, it was not reasonable or proportionate for the firm to carry out lengthy and costly searches of files dating back at least 30 years to determine whether or not the information requested was protected by legal professional privilege in order to comply. The proper purpose of subject access requests is to enable a data subject to check the accuracy of the information held by the data processor about them and to have it corrected if necessary. The purpose is not to enable a data subject to obtain documents that may assist in litigation. This is a helpful decision for employers, and it was interesting that the High Court emphasised that subject access requests should not be used as a fishing expedition. Such requests are often used by employees prior to issuing a tribunal claim, and this decision is a reminder that employers may not have to comply with them. Next, I'm going to look at the changes to employment law that come into effect this autumn. The national minimum wage rose on the 1st of October. The adult rate for those aged 21 and over is now £6.70 per hour. The other rates have increased as well. The government's new national living wage is due to take effect from next April and will add a premium of 50p per hour to the adult rate for those aged 25 and over. Further increases will take the national living wage to around £9 per hour by 2020. The power of the employment tribunals to make wider recommendations in successful discrimination cases was abolished on the 1st of October. This power enabled tribunals to make a recommendation that applied to the wider workforce, not just the claimant, such as introducing an equal opportunities policy or carrying out diversity training. The power was rarely used, so the government decided to abolish it. Previously, Sikhs who wore turbans were exempt from wearing safety helmets on construction sites. On the 1st of October, this was extended to all workplaces, so Sikhs will not have to wear protective headgear in warehouses and factories or in company vehicles. Those working in the armed forces and the emergency services will still have to wear head protection. Company vehicles must already be smoke-free unless the car is mainly used for the employee's private purposes. Drivers of private cars in England are now banned from smoking in them if they are carrying a passenger under the age of 18. Under the Modern Slavery Act, every commercial organisation carrying on business in the UK with a turnover of £36 million or more will have to publish a statement on its website every year setting out the steps it has taken to ensure its business and supply chains are free from slavery and human trafficking. The Home Office intends this new requirement to come into force in October, but has not specified a date yet. And now some employment law news items. The saga of the employment tribunal fees regime continues to rumble on. Unison lost its third legal challenge, this time in the Court of Appeal, and vowed to take its case to the Supreme Court. The Ministry of Justice has nearly completed its review of the impact of fees, and we expect the results in the next couple of months. The House of Commons Justice Select Committee has also launched an inquiry into court and tribunal fees. Finally, the Scottish Government announced recently that it intends to abolish fees for tribunal claims in Scotland. The Fit for Work service has now been rolled out across the country, and employer referrals have been available since the 8th of September. This means that employers can refer an employee to the service for a free occupational health assessment if they have been off sick for 4 weeks. Return to work plans can be accepted in place of GP fit notes as evidence of sickness. A new package of measures has been announced in relation to enforcement of the national living wage and the new living wage, which includes doubling the penalties for non-payment to 200% of arrears up to a maximum of £20,000 per worker, and considering disqualifying anyone found guilty of non-payment from being a company director for up to 15 years. The government is proposing to implement an apprenticeship levy, which will allow employers to choose and pay for the apprenticeship training they want. The levy will be collected from larger employers. Employers in England will be able to use digital vouchers to pay for apprenticeship training for apprentices aged 16 or over, and all employers will use the same system, whether they pay a levy or not. More detail on the rate and scope of the levy is expected to be announced in the spending review on the 25th of November. There are several action points that you should consider as a result of the matters I've covered in this podcast. If you engage mobile workers, you should review your working practices for those staff, particularly in relation to working time and rest breaks, to ensure that you are not in breach of the working time legislation. You may wish to obtain opt-outs in respect of the maximum working week if you have not already done so. Ensure that HR managers are aware that they can advise on law and procedure in relation to disciplinary proceedings, but should not advise on the outcome or the appropriate sanction unless this relates to consistency. Otherwise, there is a risk that any dismissal could be unfair. Consider updating your sickness absence policy so that workers are aware of their rights to annual leave when they are off sick, and notify workers on long-term sick leave of their current holiday entitlement and when it expires. If you are involved in a TUPE transfer, consider the position of employees on long-term sick leave. Are they off sick permanently, or are they likely to be able to return to work? Ensure that staff are paid at least the national minimum wage, and start planning ahead for the national living wage. Lastly, if the Modern Slavery Act applies to your organisation, start thinking about preparing a statement on the steps you have taken to ensure your business and supply chains are free from slavery and human trafficking. I hope you found this podcast useful. Please get in touch with your usual Bond Dickinson contact if you have any queries. Thank you for listening.